So welcome to the afternoon panel discussion, where we will discuss about the relationship of between independence and impartiality of courts and of tribunals and other articles of the convention. I guess that this panel discussion will be equally interesting as discussion we have this morning, and I know that many of you in regional hubs are very looking forward to hear, what we will have today. Before I give floor to judges on this panel, Judge Paul Lemons and Judge Blanco Lubarda and Judge Jovan Ilievski, I will give the floor to my co-moderator on this panel, Judge Eric Wennerstrom, so to say a couple of words before we start with the opening remarks today.
Thank you very much. Thank you very much, Goran, and good afternoon, everybody. Let me just tell you and assure you that I'm looking forward to this immensely. The discussions this morning prove that there's a lot of knowledge in this room and the 7 other rooms that are linked up with us by video link, and I'm looking forward to a very fruitful discussion this afternoon as well. I just want to say that, and in the interest of ensuring that everybody gets a chance to speak, I will limit my introductory words to precisely that. Thank you.
Thank you. As all of you know, we have time after introductory remarks from judges, so all of you from regional hubs can ask questions. So we will have two groups, and so we will hear hub by hub, and the moderators will ask questions. So first topic that we have on this panel is the relationship with other aspects of Article 6, including presumption of innocence, the right to hearing within a reasonable time, the right to a public hearing, the requirements to provide reasons for judgment. So I'm giving floor to Judge Jovan Ilievski.
Thank you. At the beginning, I would like to greet all the participants in this forum and express my satisfaction to be part of it. At the same time, I would like to thank the organizer for the excellent organization of this event in this, I would say, challenging time. Like some of the other colleagues, I will use the privilege of speaking my mother tongue, so I will switch in Macedonian.
The principles of independence and impartiality of the judiciary apply and require judges to be impartial and independent. So when we speak about these issues in relation to other aspects of fair trial under Article 6, we can mention, of course, presumption of innocence, the right to be heard within reasonable time, and the right to a fair and public hearing. It can be said that there are certain overlappings between presumption of innocence and requirements related to impartiality and independence. We can refer to a judgment in the case of Lamens versus Latvia. In this case involved extortion, and at that time the biggest bank in Latvia was Baltic Bank, and a couple of interviews were given to print media where it was stated that it wasn't really sure whether the defendant would be found guilty for all the offenses he was charged with, or for only some of the offenses. So the defense attorney asked for a judge to withdraw. How? well, of course, the claim was that the judge was not objective and that the right to a fair trial was violated. The European Court of Human Rights, in its judgment, emphasized that the presumption of innocence meant that the members of the Judicial Council, when discharging their functions, do not act with a preconception that the defendant had actually committed the offense concerned, and the burden of proof lies with the prosecution. So certainly the judges hearing a specific case have to refrain from giving public statements about potential guilt of the defendant. Even in the absence of a formal statement, judges should refrain from expressing views according to which the defendant is believed to be guilty. Also, they should refrain from talking to the media about any suspicions related to any of the parties to the proceedings. So in this specific case, the court found that this judge, when she was giving an interview, openly expressed her views and excluded the possibility for the specific defendant to be not to be found guilty. So this leads to lack of objectivity and violation of the right to impartial trial. I've tried to single out some of the Macedonian cases which are relevant to our topics of discussion. However, due to time constraints, I'll mention only three: Stojmanovic and Milosevic case versus North Macedonia. European Court found violation of Article 6 of the Convention regarding the right to a fair trial. The first instance court in this case, in which the applicant was involved, one of the judges was the judge which used to be a judge of the Court of Appeals, and also she was handling a complaint filed by the same applicant in a different proceedings. The loan agreements, well, were not identical. And the court actually accepted, despite this fact, that these elements were quite similar, although not identical. Also, the court took into account that the decision of the Macedonian court was made at a non-public hearing. So the judge concerned was aware of the fact that she had already been involved in another case involving the same applicant, and she did not ask for her recusal. So the composition, according to the court, the composition of the Supreme Court was not in line with the standards of the Convention. In the Ivanovsky case, the applicant disputed fairness of the process. He complained about lack of impartiality and independence of courts on account of public statements given by political officials and court officials. And according to the European Court, the administrative court in this case did not ensure fair hearing of the applicant as a result of the political interference with the work of judges. Consequently, the court found violation of the applicant's right to fair trial. In this context, it's important to ensure principle of equality. Although in this case, the court did not think it was necessary to examine this case in terms of equality. In the case of Mata versus Poland, the European Court established that the applicants were allowed to have access to documents issued by the government. So the applicant was brought into a disadvantageous position. And in several cases versus Turkey, the court found violation of Article 6 due to the fact that applicants were not given access to documents that were used to argue their responsibility for offenses. Claims were also made against on account of lack of independence and impartiality and fairness of the process. In some of these cases, the same judge was deciding a case involving an applicant that that had been previously involved in a different case in which the same judge was one of the responsible judges. So in one of these cases, the court believed that one of the judges did not have the sufficient level of impartiality. Actually, the impartiality to the extent which is required by Article 6. When it comes to reasonable time of trial, in some cases, the court believes that if one's same case is repeatedly heard several times by different courts, that fact indicates some serious shortcomings of the system. So we can say that when it comes to Article 6, decisions of national courts must be public, documented, impartial, and national courts must demonstrate that their judges have acted in a proper way. That will, of course, lead to increased public trust in judiciary and will represent as a safeguard from protection from partiality.
Hvala, sudija Ilijevski.
For half of the day on this, but unfortunately we don't have time to more to discuss this. But it was really excellent in this short period of time how you examine everything and explain a lot of details. So we must continue now, and now the second aspect that we're discussing is the right to an independent and impartial tribunal established by the law as an aspect of the procedural protection which arise under the convention rights. So I'm giving the floor to, without any delay, to Judge Paul Lemons, who will present this part. Please.
Thank you very much. I do not have much time, so I will be very short, but I really want to thank you and the organizers for inviting me to this forum. I find this very important, and I'm happy to be part of it. I will speak of other articles than Article 6, Paragraph 1 of the European Convention. There we have an explicit reference to the independence and the impartiality of a tribunal. My task is to see whether there are other articles in which there is a reference to such a requirement or where such a reference can be read into it. I will divide it in 3 points. My first point is about the right to an independent and impartial tribunal or other independent and impartial body as implied by other provisions of the Convention. First example that I would like to give is Article 5, Paragraph 3, which speaks of the right of someone who has been arrested or detained to be brought before a judge or other officer authorized by law to exercise judicial power. It's interesting to note that the Convention itself here speaks not only of a judge, but also of an officer authorized by law to exercise judicial power. At first view, this could mean two very different things, but what the court has said in its case law is that there may be non-judicial officers who take such a decision about the detention of a person, but wait a minute, in that case, they have to comply with a number of requirements. And the first of these requirements is then the independence of the executive and of the parties. So when the Convention itself says it's perhaps not only a court, but it could be someone else, in this case, it must be an independent other body. Other article is Article 5, Paragraph 4, is about the right to a review of the lawfulness of a deprivation of liberty, and here the Convention explicitly speaks of a right to bring such a challenge before a court. A court, not necessarily to be understood as a court of law in the classic kind, but in any event, any court must present some fundamental features, of which the most important is the independence of the executive and the parties. My last example is Article 13, the right to an effective remedy before a national authority in case someone has a credible allegation of violation of his or her fundamental rights. The right to a remedy at the national level means that there must be somewhere a sort of a body that can deal with the substance of the Convention complaint, the substance of the complaint about the violation of human rights, and if a violation is found, to grant appropriate relief. Now here again, the Convention does not speak of a court. And the European Court in its case law has also said that that national authority does not necessarily have to be a court. But if it is not a court, then the powers and procedural guarantees of that body will become very important in determining whether or not the remedy was an effective one. And the court also says, in fact, the best is to have a judicial remedy because then you have the strongest guarantees of independence. I could give you some examples of other articles, but I'm not going to do that in order not to make things more complicated. Second point, the right to an effective judicial procedure in case an interference with a person's human rights has taken place. Although under the Convention it should not taken place, but it has taken place. Now what sort of reaction should be available? Two ideas. The first one is a very general one, that a state has a positive obligation to provide for a judicial procedure enabling a person to assert his or her rights against another person. A judicial procedure. A procedure because the Convention places thrust in courts so that they can adjudicate effectively and fairly disputes between private persons. This has been repeated many times, mostly with respect to disputes relating to the right to property, which is a very common type of disputes before national courts. And of course, these judicial procedures are bound to comply with the requirement of independence and impartiality. This is not Article 6, it's Article 1 of Protocol number 1 that contains this procedural obligation. The next step is a step further. Sometimes, in case of really very serious interferences, it's not enough to give an opportunity to the victim to bring a case before a court. The idea is for very serious interferences with the right to life or with prohibition against torture or ill treatment, sometimes also with very serious interference with the person's private life. The state has to do everything in order to avoid such interferences. That means a strong legislation against them. But if an interference has taken place, it should also show that there is a mechanism that can react and that can react in an effective way. Sometimes, when the interference has been intentional, a criminal law reaction is needed. And that is then one that is not left to the initiative of the victim, but that requires an ex officio reaction by the public authorities. If it's an unintentional interference, when negligence was the cause of an interference, think for instance of accidents that took place in a medical environment, in a hospital environment, then a remedy of a civil nature may be sufficient. I come to my third point. Procedural guarantees read into the Convention as elements of the necessity requirement. And here again 2 points. First of all, procedural guarantees have been construed by the European Court in its case law as elements to counterbalance an interference with a person's rights. We know from the text of the Convention that an interference must be provided by law, must pursue a legitimate aim, and must be necessary in a democratic society. Well, about this last condition, the necessity of the interference, which implies a proportionality requirement, the court on occasions has said this requires also a sort of a fair decision-making process, so that the person who will be affected by the interference, by the measure to be taken, that person has the possibility to present his or her point of view before the decision is going to be taken. And the wider the discretion is of the body that is competent to take the decision, can be an administrative body, can be a court, the more there is a need for a procedure that complies with the requirements of independence and impartiality. That can be a procedure leading up to the decision, or that can be a procedure reviewing a decision that has been taken. To give you one example, in the recent case law of the court, it's about the control on bulk interception of communications. Here the court has said that there is indeed a need for independent and impartial reviews at various stages of the process of interception of personal and other data. Not necessarily a judicial review, but an independent review. The same principles apply also with respect to interferences with freedom of expression, but given the running of the time, I will not go into that. I think that maybe Branko will say something about the Baca case that relates to Article 10, and that has to do with procedural guarantees in proceedings against a judge. My second point here is that the quality of the decision-making process has become also an element in the court's review of the compatibility of an interference with the Convention. As you know, domestic authorities most of the time have a margin of appreciation in which they can choose to take various decisions as long as they balance the rights against the general interest and other interests involved. And how now does the court carry out its review of acts and omissions of national authorities. We call that now a process-based review. It contains a review of the procedural guarantees that have been afforded. Guarantees that I mentioned that are sometimes explicit in the convention, sometimes implicit. Secondly, the court also reviews the reasoning of the domestic authorities. This is half procedural, half substantive. Is the reasoning relevant? Is the reasoning compatible with the convention? Is the reasoning sufficient to justify the decision that has been taken? When the European Court finds that the reasoning was insufficient, well, the conclusion usually is very simply the measure is not compatible with the European Convention. But where, on the other hand, the domestic authorities and very often the domestic courts have carefully examined the facts, applied the human rights standards that can be found in the Convention as explained by the court, and when they adequately balanced the individual rights against the public interest involved, then, as the court nowadays says, it would require strong reasons to substitute its view for that of the domestic courts. It doesn't stop there. There is, of course, also a control, a substantive control on the outcome of the decision-making process. Was there proportionality, etc.? But in many cases, it stops already at the control of the reasoning of the domestic decisions. And this leads me now to my conclusions. Procedural requirements are not only explicit but also implicit in the Convention. And these requirements imply often a decision-making or at least a review of a decision that has been taken by an independent and impartial body. A body. I'm speaking deliberately of a body. Because while judicial involvement is not always required, it is nevertheless in principle desirable to entrust supervisory control to a judge, and now I quote from the case law of the court, because judicial control offers the best guarantees of independence, impartiality, and the proper procedure. And with this, I would like to return to what our president said this morning. This is about the confidence put in judges and the judiciary. But this puts at the same time also a high degree on responsibility on judges. The public confidence the judges and the judiciary must have in order to carry out their functions is something that must be earned by judges and by the judiciary. And with this I stop, and this will, I think, bring us to Branko's presentation. Thank you.
I agree. I mean, working with victims for so many years, I remember that many victims of human rights violation, especially those in small municipalities, will always rather have a court. And even when the fact that they are sometimes before the court is justice for them, even before judgment is delivered. So this is a big encouragement when they are in small municipalities. But I will not take more time, so we are going to third part of the panel. I will give floor to Judge Branko Lubarda, and he will talk about rights of judges, striking balance between protecting the rights of judges as individuals and the requirements for them to preserve the independence and impartiality of the judiciary during their duties. Thank you.
Hvala Gorane, poštovane kolege.
Thank you, Goran. Dear colleagues, I would like to firstly thank the organizer for inviting me to this very well-organized forum. I would also like to congratulate the publishers and Lady Branko and Hannah Smith as the main editors on the publication giving a compilation of case law of the European Court. So I would just like to mention that in this context, 3 judgments have been delivered involving Serbia. Šodić from 2012, where violation of Article 6 was found. Then Paunović versus Serbia from 2019, where no violation was found. And Svilen-Gaćanin and others dating at the beginning of this year. As you can see, the topic I'm going to address is the balance between independence and impartiality and the rights of judges, which means I will restrict my presentation to the case law where judges or former judges or presidents of courts were applicants in cases. So we can see that the court has found violation of Article 6 in many cases. For instance, Deniso versus Ukraine, where Grand Chamber was involved in 2019, Rambachov and Sal versus Portugal in 2018, Raden versus Slovakia 2012, Olovic versus Croatia 2009, Mitinovsky versus former Yugoslav Republic of Macedonia in 2015. And let me add to that the judgment from the beginning of this year, Bilgin versus Turkey. This is where absence of possibility of judicial review was found. Judicial review of a transfer of a judge to a different court. In many cases, the court found not only violation of Article 6, but also other articles. For instance, Volko versus Ukraine from 2013. In addition to violation of Article 6, the court also found violation of Article 8, where especially relevant, as Paul already said, is the judgment of the Grand Chamber in Baka versus Hungary from 2016, where the court found violation of both Article 6 and 10 of the Convention. Also, in the most recent case law, the court found violation of 3 articles in Emin Agobu versus Turkey from 2021. Violation of Articles 6, 8, and then 10 of the Convention was found, which was a special testimony, to put it that way, with respect to pressure on independence of judiciary. The case was involving disciplinary measure and transfer to a different court because of a criticism of a judge, which at the time was also the president of the Association of Judges and Prosecutors. His criticism expressed in the media. So the court found that the restriction to the freedom of expression which was imposed was not supported and followed and accompanied by relevant safeguards. So the court found only other violation, not violation of Article 6, for instance, in Vile versus Liechtenstein, violation of Article 10 was also found, but also of Article 13, or in Kudeshki versus Russia from 2008, for instance. Only Article 11 was found to be violated in Grand Chamber's case in Maestri versus Italy from 2004. Here I would like to bring to your attention the decision of the court in Pitkevich versus Russia from 2001, where the court defined that the claims of the applicant were clearly, manifestly unfounded. Her claims related to violation of Article 9 and 10, and the court found that her dismissal was proportionate to the legitimate goal, because she clearly violated her legal obligations as a judge, and she also violated or damaged the appearance of impartiality that she must demonstrate. So the basic characteristic here is that judges are believed to and considered to be persons that, just like all other persons, enjoy freedoms and rights. However, their enjoyment can, in certain circumstances, affect the impartiality and independence of judiciary, and therefore a proper balance must be established in this respect. The only thing I have to add to this holistic approach, which was very well presented in the publication, is to bring to your attention some more recent judgments of the court, which are also worth being mentioned. Emina Goglu versus Turkey is especially relevant from March this year, and Milgen case, which I already mentioned. Let me, however, take a step further concerning and in relation to the concept and approach of this publication. The court has dealt with several segments or elements of independence. Independence in relation to the parties to the proceedings, independence in relation to the executive and legislative branch of power, as well as internal judicial independence, such where we have the discretion case as an example. In certain cases, the court was analyzing the independence of judiciary from the perspective of the rights of persons which are involved in judicial proceedings. In this context, Alexis Tocqueville's words are highly relevant, who in his book about democracy in the US says that there's nothing that improves the welfare of a nation as a properly organized judiciary. But we have to ask ourselves whether the case law of the court regarding Article 6 can be also seen from the perspective of subjective perspective of judges whose personal independence has to be guaranteed.
Američkog suda za ljudska prava.
Inter-American, for instance, the 2013 case versus Ecuador or the case versus Honduras from 2015 are relevant. More precisely, Article 8 of the Convention on the Rights of Human Men recognize not only the rights of individuals appearing before judges, but also the rights of judges to have their independence guaranteed. Our colleague had a dissenting opinion in the Baca case, and he said that the rule of law can hardly be imagined without the duty of a state to offer safeguards for the protection of judicial independence. And he, by saying this, applies a logical and theological approach, referring to the Vienna Convention and the case and the practice of the UN Committee, for instance, their decision in Badanaraike versus Sri Lanka from 2008. But also, while doing this, Magna Carta was also taken into account from the document from 2010, according to which independence and impartiality are important prerequisites for the work of judges. So judges have subjective rights in this respect. This kind of opinion, this kind of approach has been supported by the academia. For instance, Professor Peggy Ducoulombier from the University in Strasbourg, who draws attention to the need to interpret the provisions of the Convention in line with other international documents. She also says it's important in the case, involving Hungary, right to access to information was, according to the applicant, was violated. So the same interpretation should be applied in this case as well. Also, we had a colleague that disagreed with the opinion of the majority in the Baca case, another colleague. But I would like to say that, of course, impartiality and independence are crucial. But also there's this fact that since 2016, the European Court has delivered, for instance, in cases Denisov Rumes. I apologize. He's just actually going too fast. In several cases, I believe it is a legitimate question can be asked of whether the case law can identify the elements of recognizing a subjective right to independence of judges. So, in addition to this, if we carefully read the publication, we can see that when that the authors, when considering other rights of judges, they draw attention to the need to consider specificities of certain contexts. For instance, measures taken to deprive judges of their liberty have to be subject to more rigid procedural safeguards against arbitrary approach. So the speech of the President's panel was, he also referred to this when he gave his speech this morning. Also, the case from 2019 versus Turkey resulted in judgment saying that the courts have to pay special attention when defining the conditions under which deprivation of liberty was took place, and that special attention must be given to predictability criteria. The court protection, judicial protection of this kind is granted to judges not for their personal gain, just like Robert said this morning, but in order to ensure guarantees that judicial function is performed in an independent manner. Or in the context of Article 8 of the Convention, the case law of the court is such that it is allowed to require judges to act in a reserved manner in their private life in order to avoid any damage to their reputation and the appearance of impartiality. But at the same time, the court says that interference with their right to private life must be in line with the principle of proportionality. Therefore, they can be dismissed from, removed from office for their actions in their personal life only if it's proven that affects their professional performance. Optional case from 2010 is relevant. Procedural guarantees are they are very important in investigating their personal life actions. When it comes, however, to the effects of dismissals, effects on the private life, in order for a dismissal to trigger the analysis of potential violation of Article 8, it must lead to serious consequences regarding reputation or serious material consequences. Denisov versus Ukraine from 2018 is here relevant. The applicant here complained about, said that their right to private life was a violation because he was removed from the office of the President of the Court of Appeals. But in this case, the court did not find that this threshold regarding seriousness of consequences was met. Finally, we have already mentioned Article 10 and relevant case law, Eminenoglu case, as I mentioned, and the publication pays special attention to, for instance, Vile versus Liechtenstein or Kudeshki versus Russia, but primarily Baca versus Hungary. It clearly is the duty of judges to refrain from publicly commenting on the cases they are involved in. Also duty to discretion, and also sanctions should be imposed on judges that publicly gave statements about uncorroborated corruption claims. We had this case from 2016, or where a judge was spreading rumors, unfounded rumors about a colleague, from where we had this case versus Italy, because these cases, these situations can seriously damage the appearance of impartiality of judges in public. On the other hand, the duty of judges, this duty of judges is actually fundamentally serving to uphold rule of law. And on the other hand, none of the restrictions on the freedom of expression of judges must be can have a deterring effect on their willingness to take part in the public debates on issues important to judiciary. Kudečkina versus Russia is especially relevant here, or Baka versus Hungary, and Emina Noglu versus Turkey from 2021. In Baka case, in the Baka judgment, states that the president of the applicant, the president of the court in this case, can express their views on the judicially related reforms. So the case law of the court can, in that case law, we can identify elements of the subjective right of judges to impartiality. Let me congratulate the appointment of Ms. Vajkovic as the judge in the Supreme Court of Cassation in Serbia. Just actually, I have had a very good cooperation with the former president of this court. So I look forward to meeting Ms. Vasovic and president of the Constitutional Court, and of course meeting other judges and representatives of other courts in the Council of Europe states. Thank you for your attention. I will try to, of course, I'm here at your disposal to answer any questions you may have, especially concerning the subjective rights of judges that we are discussing today. Thank you.
Thank you, Judge Roberta. I mean, you mentioned that quote from one judgment that judiciary has a special role. I think in this region it's more than special, it's crucial, and everything is around judiciary. If you have at least partly independent court, I mean, we will be able to proceed. So we are going further. We still have enough time since we started a bit later. So before we give the floor to Judge Darian Pavli, I will give the floor to Judge Erika Lenstom if you want to give some remarks after these speeches.
Well, thank you very much. I really only wanted to thank the panelists for their insights here, and I recall something that Branko Lobarda just made reference to, the need for a holistic approach to independence and impartiality, which is something we also find in the conference book, and I think that's worth reflecting on. More than 20 years ago, I took part in a discussion that started on a premise that if you can guarantee the separation of powers, that is enough to guarantee the independence also of the judiciary, which I didn't quite agree to. Being separate is not the same as being independent. I think that goes in the direction of what Pavel Uslatov this morning called technical independence, which is something that may actually stand in the way of discerning destructive or detrimental dependencies. And I think that the fine-tuning of the case law that we have had references to here demonstrate the need for digging further than the first appearances of independence. That is really all I wanted to share. But again, thank you very much.
We are still there. So I hope that Judge Darian Pavli is with us online, at least virtually. So we are waiting a second to see. Yes, we have Judge Pavli. Judge Pavli, the floor is yours.
Thank you very much. I hope you can hear me.
Very well.
Sorry. Hello, can you hear me okay? Excellent. Well, hello to everyone. I regret that I'm not able to be there with all the colleagues from the court and from the region, but I want to thank the organizers very warmly for allowing this opportunity to connect remotely. Not to waste too much time, I want to get quickly into what I wanted to talk about, and it is in a way complementary to the old discussion of judicial independence. It is not about any particular article of the convention, but I wanted to touch on the relationship between independence and accountability. And I think it goes a little bit along the lines of what my dear colleague Judge Wennerstrom was talking about. Accountability in the general sense of the judiciary and the judicial system. Now, it may seem like a conflicting relationship, but I think it is very much two sides of the same coin, because it is very difficult to consider that a judiciary that is not accountable to the general public, that has, for example, integrity challenges or disciplinary issues or professionalism issues, can be truly, or conflict of interest issues, as we've heard, can be considered truly independent. As it has been often noted, independence is first of all a state of mind. In this context, I'm of course more familiar with the situation in my own country of Albania, and what I could say very briefly is that one aspect of the recent justice sector reforms that we've had in Albania has been driven by this concern that the previous institutional arrangement was unable to ensure. It had quite a bit of independence, especially at the level of the judicial governance bodies, the High Justice Council, where a majority of the membership, a great majority, was elected by its own peers, by magistrates, but for various reasons that it would take too much time to go into, it was unable to ensure either genuine independence from political influence and also accountability, especially in terms of the integrity of the judiciary. And that is one of the things that have led to a complete overhaul of how that body, the judicial governance bodies in this at this time, which include one that oversees the prosecution, have been structured. I think there are parallels to this in the case law of the court, and I would refer to two cases in particular. Apologies, I need some battery. The first one follows from a case from more than 10 years ago, Kolevi versus Bulgaria, and what the court found in this case, which involved some fairly serious allegations against the highest prosecutor of that country, the prosecutor general, allegations of a serious criminal nature surrounding the death of the applicant, which had been himself a senior prosecutor. What the European court found in that case was that there was a structural deficiency in Bulgaria, whereby there was no mechanism for the independent investigation of the prosecutor general himself, when there were serious reasons to believe that he had to be investigated. It is a complex set of issues that we see in other countries. The reality of it is that more than 10 years after the judgment from the Strasbourg court, the situation appears to remain the same in Bulgaria. It has generated a great deal of discussion over more than a decade, opinions by the Venice Commission, including an opinion of the Bulgarian Constitutional Court, which at least in spirit seemed to go against the decision of the Strasbourg court by finding that there was no need for a constitutional amendment. The issue is still unresolved, and it's very much one of the big rule of law questions in Bulgaria. A second case I would mention, and this is actually in some respects quite similar to the line of cases discussed just now by our esteemed colleague Judge Lubarda on the relationship between judicial independence and the Article 10 rights of judges and prosecutors. And this is Kaveshi versus Bulgaria, which involved a senior anti-corruption prosecutor, my apologies, Romania, Kaveshi versus Romania. It involved a senior anti-corruption prosecutor who was proposed to be either removed from office or not nominated again by the Minister of Justice. And apparently this was something that was driven very much by Ms. Kaveshi's critical public statements about certain reforms that were being undertaken by the government of the judicial sector. And it was also quite striking about this case. It was seen widely as a form of interference by the executive into the affairs of the prosecutorial branch. And in fact, both the High Judicial Council in Romania and the President of the Republic refused to countersign the proposal of the minister to dismiss the senior prosecutor. But it was then upon a decision of the Romanian Constitutional Court that the President of the Republic was essentially was told by the Constitutional Court that he had no choice but to countersign that decision. Now, this led further down the line to a decision by the Strasbourg Court finding that Ms. Kaveshi's rights had been violated under both Article 6 and Article 10 of the Convention, her freedom of expression and her right of access to a court. And as you may know, this lady has now been appointed to be the chief anti-corruption prosecutor for the European Union in this disbursement of many billions of European Union funds. I bring up these cases. Another recent example would be, I don't have time to go into it, but what is happening in the Ukraine with the recent strike down by the Ukrainian Constitutional Court of the criminal legislation, which makes it a crime for anyone, including judges, to lie or disclose their assets under the laws of asset declaration. And this is a fairly complex controversy, but one aspect of it that has been, to my knowledge, for example, criticized by the Venice Commission, is that there did not seem to be anything particularly problematic with this particular provision of the criminal law, and it was one that is widely used in many member states of the Council of Europe. To sum up, what I wanted to convey is that while judicial independence is certainly a must for any individual judge and for the system as a whole, it is possible. I don't want to say, it might be too provocative to say that there can be one thing as too much independence in the sense of the system as a whole. And I only mean that in a provocative sense, but it is, you cannot have genuine guarantees of independence also without having a system of accountability for a working and functional system of accountability for the judiciary and the prosecutorial branch, ideally run and governed by the branches themselves in a self-governing fashion, and if necessary, then with additional safeguards. Thank you very much.
We will turn to the hubs across the region, where I am sure that the discussions this morning and this afternoon have generated a lot of questions. We will follow the same format as we did this morning, only in reversed alphabetical order. starting with 4 hubs, then breaking for answers, and then taking the remaining 3. And we are again recommending I ask my fellow panelists to take close note of these questions, as we'll be turning to you once we're through. With that, I invite Zagreb to start this question and answer session. Zagreb, over to you. Thank you.
Hello, hi from Zagreb. Well, at this moment, it seems that we don't have any questions now for the judges in this panel.
Thank you very much. Voila. I take that as a very good sign of the quality of the discussions you have been listening to so far. And with that, I turn to Tirana. Please.
Ombudsman of Albania, Minister Inda Balanta, has one question.
Thank you very much for this very interesting presentation during all the day. I appreciate it a lot, and definitely I consider as part of the communication of the court with the people of Council of Europe. So in a way or another, it is what Judge Spano said earlier, communicating the intentions, the decisions of the court, and the way of thinking. It's very important to make people continue to believe in the court. Actually, the European Court of Human Rights is seen in Albania as one of the highest authority, and it has had absolute authority in this country for all these years of its activity. There have been, though personally I have had some questions that I'm posing now for some decisions, some recent decisions of the court. I didn't hear one of the recent decisions that were issued with respect to the reform in Albania, or the justice reform in Albania. That it is one of the most thorough reforms of the judiciary, and of course, I guess, a very severe one that has left us nearly without courts for 2 or 3 years. In a way or another, in order to have a better court system or judiciary, we were left with 0 judiciary for several years. Having said that, I would like to go to have a question to the panelists. What changed? What was the difference between the case of Iceland and the case for Georgia with respect to the court appointed by law? This is one. And secondly, with respect to the safeguards that the judges should have within the disciplinary procedures. Of course, accountability is a very important pillar of rule of law, and we think that definitely we need to have very good care of that and take it very seriously. And I agree with Judge Pabli on that our system before didn't have the desirable accountability mechanisms. However, the way how this process is done in Albania, with the reverse of the burden of proof to the judges for every single day of their lives, before becoming judges or after becoming judges, seems to me as it conflicts with the presumption of innocence. I know that the judges and that the Honorable Court has already issued a decision on that, but I would like to understand the differences between Albanian case and the other cases which were mentioned here before from this court. I consider that the democracy and interpretation of the standards of democracy is only one, and there cannot be two different gears in the interpretation of the spirit of European Convention of Human Rights. Thank you very much.
Thank you very much. While we digest the question and the panelists consider who is more keen than anybody else to answer these questions, we proceed And I now turn to Skopje to see whether there's a question brewing. Please.
I would only have one question regarding the freedom of expression of judges, especially in social media and internet space. So it would be more like a general question, regarding the current standards, like what are the current standards established by the court in this respect, and what are your expectations? How would the Strasbourg Court's case law and jurisprudence develop in this regard? So it's more like a general question. Thank you.
Thank you very much. That is well noted. Sarajevo, is there a question to the panel from you? Please.
As far as I can see, currently there are no questions from Sarajevo. Thank you very much. Can you hear us?
I understand that there is one more question from Tirana. Please.
To broaden a little bit the question by our colleague, by the Ombudsman, Mrs. Balanza, is for accountability versus the immunity that as a legal guarantee that the Constitution gives. So I wanted to discuss this also in this context, if Minister Pavlio, Judge Pavlio, other judges are going to respond. Thank you.
Thank you very much. I check with Sarajevo once again whether there was a question or not before we turn to the first answers.
No, maybe you didn't hear it. No, there are no questions from Sarajevo Hub at the moment. Thank you.
Okay, thank you very much. Then we turn to the first round of answers here. And concerning the questions we have received from Tirana, I suggest we start in the direction of Paul Lemons here, please.
Yeah, I think that the question about the vetting process in Albania is somewhat directed to me. I was part of the chamber that decided that there had been no violation of Article 6, paragraph 1 in the proceedings that had led to the dismissal of one of the judges. I don't think it would be appropriate for me to enter into a discussion on a case that I have been deciding with other colleagues. I just would like to indicate that indeed in the judgment it has been said that both the Independent Qualification Commission and later the Appeal Chamber, that they had been appointed in a way that was in accordance with the procedure prescribed by law. These were not judges who had been appointed to these newly established bodies, which I think is understandable if one understands that the whole idea behind the vetting process was to vet the whole judiciary. So then you must look for people who are capable to do that, who are not themselves members of the judiciary. That is what the court in its judgment explained. Another aspect was the fact that the Independent Qualification Commission started the investigation, examined what had happened, and then took the decision. This is not uncommon, for instance, in disciplinary procedures. What is important then is that there is also a right to an appeal to the decision taken by that body, semi-disciplinary body. Was not a disciplinary body, was a vetting body, and the court also found that that was a condition that had been fulfilled in this case. I'm not going to get further, I'm not going to compare this case with other cases of our court. This would not be appropriate for me. I just tried to explain for a broader audience what the court said in this case of Chocai versus Albania. Thank you.
Thank you very much. Judge Lubalda, would you like to continue?
Thank you, Mr. Chairman. I would like to make reference to the resolution of judicial ethics it is entered into force the 1st September this year of the European Court of Human Rights dealing with the ethical issues and expression and contacts. This resolution of judicial ethics mentioned in point 6 that judges shall proceed with the utmost care in using social media. But to put it in the general framework of our approach related to the judges of the European Court, I would read the whole point 6. Judges shall exercise their freedom of expression in a manner compatible with the dignity of their office and their loyalty to the institution of the court. They shall refrain from expressing themselves in whatever form and medium in a manner which may undermine the authority and reputation of the court or give rise to reasonable doubt as to their independence and impartiality. And this applies equally to the exercise of judicial function, representation of the court, and to academic and other public or private activities outside the court. We discussed also a lot about several other aspects of freedom of expression, especially in respect of separate opinions, but this is all what was included in our resolution of judicial ethics. So this is my reply to one of the questions or other comments in respect of the freedom of expression and in more particularly in respect of using social media. Thanks.
Thank you very much. Would Judge Ilievski like to? It was not directed towards you. Well, thank you very much. In the interest of reaching all the hubs, I suggest that we proceed, and I ask if Pristina has any questions for us. And they do, I understand. Please.
Hi, Pristina has one question for you, which will be addressed in Albanian by Judge Avni Mehmeti, who is a representative of the Kosovo Judicial Council.
Atëherë, të nderuar panelist, kryetari i gjykatës.
Dear panelists, dear President of the Court, dear Presidents of the European Court for Human Rights, dear representatives of the regional countries that are taking part in this forum, I would like to ask a question regarding the external independence of the judicial system. First of all, I'm honored to be able to participate in this forum as representative of the Judicial Council of Kosovo. So this question has to do with the financing of the judiciary, as this is one of the important segments of external independence of the judiciary, because we know that national and international regulations do provide guarantees for the division of powers. And one of the things that is concerning us in the country that I'm coming from is the financing of the judiciary, the funding of the judiciary, because you know that the budget for the funding of judiciary is proposed by the government, and it is then adopted by the parliament. So I would like to hear from the European Court of Human Rights as to how this affects the independence of the judiciary. I'm talking about situation where financial requirements and the amounts awarded in the judicial budget are not sufficient for the proper functioning of the judiciary. And this budget allocations, of course, affects the selecting of staff and the functioning of the system as a whole.
Very important question that every system has reason to consider often, no doubt. Thank you very much. We proceed also to Podgorica, please, if there is a question.
Hello again from Montenegro. I would like to say all we can see this topic for forum. It's very interesting and for this also for discussion and for questions. And now I would like to pass the floor to Judge of Supreme Court in Montenegro, Mr. Miraž Radović. We have one question, please.
Thank you. First of all, I would like to greet the organizers of this event and all of the participants. And to say that this is a very successful event with an extraordinary topic. And I would like to ask a question. I believe it would be most fit for this question to be asked, to be answered by Mr. Lubarda, given the topic that he has been covering. And I wish to say that this panel indeed is connected with the first panel, just like the independence and the impartiality of judiciary are, the way they are connected. So what this is all about, the question. My question is, in which measure does the European Court of Human Rights, in which part it has dealt with the right to reasoned judgment when concerning decisions regarding careers of judges? Why I picked out Judge Lubarda, he was talking about Baca and Denisov and Volkov cases, and in all of those cases, this was actually about the cessation of the judicial judges' function or dismissal of these judges, and it definitely looks like that there can be no dispute that when it comes to the dismissal of judges, such a decision rendered on dismissal needs to be reasoned decision and provided in detail. I have my own standpoint, of course, on this, and I'm not just talking about dismissal, but also, you know, applying for a position or going to upper positions in your career. Sometimes you're, for example, nominated for president of the court, but then the collective authority, collective bodies giving no reasoning of a particular decision that they have taken. For example, they just say for 5 out of 4 and so on and so forth, he has been accepted to this position or he has not been accepted to this position. So we're talking about, not about dismissal, but, you know, going to a particular position. Is this something that undermines the principles of judicial independence, since the career of a judge is something that is most closely related to judicial independence?
I think that's also a very crucial question, because the type of decisions that will affect the career of a judge is not only of one nature, but can in fact be a whole range of different decisions taken throughout the career, and we have reason to regard them all. Thank you very much. I will now turn to Belgrade, please.
Thank you, Mr. Chairman. We have one question. It will be posed in Serbian language, and the question will be posed by Ilić Vladica. He is a lawyer at the Belgrade Center for Human Rights, which is one of the most prominent non-governmental organizations in Serbia. Please, Vladica.
Hvala. Thank you. Good day to all. I would like to greet you all, and I would like to ask something that has to do with the right to independent and impartial tribunal as a procedural guarantee for other convention rights. I'm referring to the Article 3 of the European Convention. So, and also there is this life sentence, because the case law thus far, the court many times actually found that it is not up to them to tackle the issue whether the review of life sentences should be reviewed by the judicial or the administrative procedure, because the court allowed. Actually, they didn't see that that it wasn't contrary, for example, it's not contrary to Article 3 for president to maybe give a presidential pardon, and but. Of course, there needs to be a stricter control of judicial practice when it comes to giving pardon. And in almost all of the cases, there has been found this breach of Article 3. Except in cases such as Kafkais. So is this really in harmony with Article 5 of the Convention? Because it clearly says that when it comes to deprivation of freedom of a person, this is something that ultimately needs to be decided upon by the court. Because when it comes to life sentence, we have somebody who's already deprived of liberty. But also the review of such sanction, it's also a decision regarding the freedom and the limitation of this right to freedom. So is this right also going to be limited to a certain, for a certain period of time? Also, there are other things such as the president not having the qualification, and the appointment of president is not, doesn't match the appointment procedure for judges. He's somebody who's or she is responsible towards citizens upon elections, and. So do you think that this relation between Article 5 and Article 3 that I mentioned before, I mean, at least it seems to me, can we maybe expect for the court sometime soon that that the court might, after all, decide that the revision of this life sentence needs to be done before the court, after all? And as I believe is the case in the United Kingdom.
Thank you very much for this interesting question concerning the right to pardon or commute by the head of state sentences of life incarceration. Before turning to the panel, I would also like to turn to President Spano, who was asked for the floor. Please, the floor is yours.
Thank you very much, Eric. I thought I would maybe just say a few words just to give an extremely brief structural overview of which sort of compiles, I think, many of the questions that have been raised, and I think is important when we are dealing with the issue of judicial independence. I think it's important to divide three different types of scenarios that we are talking about. Number one, entering the judiciary. The procedure for entering the judiciary, what are the requirements under the convention? That's Article 6. The tribunal, the procedure must be in accordance with domestic law. Domestic law is the benchmark. The court will review under the three-part Austrason test whether a judge appointed, a person appointed, has fulfilled those requirements. The second is once a judge is in the judiciary. That is the status and the functions of the judge while he sits. That is based on the requirement that he retain both de jure and de facto independence. De jure in the sense that his situation must be secure, security of tenure, and so forth. When it comes to financing, when it comes to salaries, the Strasbourg court has not as yet taken a position on to what extent the financing of the judiciary or the reduction in salaries would create an Article 6 problem. But the European Court of Justice has, in the Portuguese judge's case, and has made clear that salary reductions, in principle, can create a problem for the purposes of the requirement of independence under Article 19 TEU, which is a provision which we do not find in the Convention, but also under Article 47 of the Charter, which is Article 6. The final factual scenario is leaving the judiciary. accountability, judicial reform. That can be done in two ways. It can be done to structure differently the judiciary. That is something a legislative prerogative has. Restructuring the judiciary as a government function is fine. But when you are stripping or cleansing due to corruption in the judiciary, we have an overarching principle, the principle of the irremovability of judges, which comes into play. But that is not without exception. All of these three steps are based on different types of analyses, and it's important to make that distinction. And it is also important to realize that first one entering the judiciary, only Article 6 for the convention purposes. The second, within the judiciary, Article 6 and 8 can come into play, allowing for the subjective rights of judges to be protected, leaving the judiciary, dismissals, and even internal disciplinary proceedings. That is Article 6 and 8. So looking at it in these three steps and making that doctrinal distinction is extremely important, and also for comparison between Guðmundur Andri Ástráðsson and Čočaj versus Albania, because Ástráðsson is the first step, Čočaj is the last step. And so the way in which the principles play out may be different from whether you're entering the judiciary or whether it is a process of removing from the judiciary.
Thank you very much for that clarification, which I thought was very helpful. I now turn to our panel, and I start again looking to my left, whether Judge Lemmens would like to add something to the questions that we have heard. Please.
Yeah, I think I would like to say something about the last question about review of the life sentence, the role of the courts and the presidential pardon. Under Article 3, there is the right not to be submitted to inhuman treatment. And the court has said if you are convicted to a life sentence without any possibility that you ever might leave the prison, not even when you have completely changed into a different person, then that is an inhuman punishment. That is Article 3. That is the substantive part of the issue. How can you arrange for such a possibility? There are various ways. And it can be that the competence lies with a court, competence can lie with another body. It's not necessarily a court, but where it is purely discretionary, without any legal framework, without any criteria that are set before, and so that a prisoner cannot try to comply with the criteria and then come into a position where he or she is eligible for leaving the prison, well, then there is a problem with Article 3. And that brings in the presidential pardon, which is in some countries purely discretionary. That will then not satisfy the requirements of Article 3. Is it a matter of Article 5? Yes and no. We are dealing with prisoners who have been convicted. So convicted by a court, and in this case convicted to a life sentence, that is in principle a sufficient basis for being in prison during the whole time, except when it becomes something contrary to Article 3. If a prisoner wants to argue that the detention, the continued detention, without the possibility of being released, that constitutes a violation of the convention, then under Article 5, paragraph 4, that person has the right to complain to a court. That is not the same as saying that it is the court that must be able to grant a pardon or examine the conditional release. That's not exactly the same. It's about taking a decision versus examining the legality of a continued detention. That is what I would like to say at this point.
Thank you very much. I turn to Judge Roberta. I believe one of the questions were directed to you specifically.
Thank you, dear Eric. Dragi kolega Miraš Radović je postavio.
My dear colleague Miraš Radović asked two questions. Ksenia basically responded to question number 1 and Robert too. Let me just remind you that in Ástráðsson case, all of the candidates that were nominated met the criteria, the selection criteria. However, the minister, lady minister, departed from the order in which these candidates were proposed. And the minister may have such discretionary power. However, that kind of decision was required to be explained, reasoned, and the reasons were supposed to be given for such decision. Given that in this specific case, this was not done, Ksenia and Robert very nicely explained this. That's why the judgment was delivered the way it was. When it comes to the other issue, let me just remind Mirage of Ramos Nunes versus Portugal case. Our court in Strasbourg here found that the Supreme Court failed to exercise their discretionary powers based on adequate factual basis. The court also held that the issue of necessity to assess facts about the I'm sorry, he's just reading out the judgment. So, in this case, the review of the scope of review, of judicial review, was the matter that was considered. So, having in mind this, in addition to the absence of hearing during both the disciplinary proceedings and judicial consideration of appeals, the court found that this case was not heard in line with Article 6. So these two judgments, I truly believe, are vital if we want to find answers to the questions and comments of the fellow Judge Radovic.
I believe that as regards the question posed to us from the Pristina hub concerning the independence, external independence of the judicial system, and in relation to money or funding is one of the issues where we will not have a whole lot of guidance from case law, from experience, different European experiences. We know, and sadly that does not give us an answer, that from the mid-90s and forward, when the issue of judicial systematic independence was considered, and many countries considered the introduction of judicial councils as a means of immunization, to use a very timely word, immunization from politics of the judicial systems, which later turned out not to be entirely foolproof. Certainly, it did not cater for the independence of from funding, although that was considered in many instances, but there did not seem to be any way around that, unless anyone would like to volunteer ideas. I think this is as far as we will get with the questions, and I would like to thank all of you involved from my part, and turn over to Goran.
Thank you. This was our second panel discussion for today, and now we have, according to plan and agenda, we have a coffee break, and after coffee break in the regional hubs, we will have a regional working groups that will continue until 5 o'clock. So this is the program for today. Thank you for this panel, for judges especially in this panel discussion. I hope we did our best in this very, very limited amount of time. We were in delay, I mean like 15 minutes, I think, but we did really our best. Thank you everyone.